Today we are going to explore the burden of proof. There are two ways lawyers can prove something in court. The first way is through what we call direct evidence. Direct evidence is evidence that clearly shows a person or group of people has committed a crime. The second is by offering circumstantial evidence. Circumstantial evidence doesn't directly and clearly show the person must have committed a crime, but instead shows that this person could have committed the crime.
Now let's talk about what burden means. In a legal case, the burden refers to who has the responsibility to prove the evidence of the crime. In all criminal cases, it is the responsibility of the prosecutor to prove that someone is guilty of a crime. And just like there are different types of evidence, there are also different types of legal burdens. And these different burdens of proof can be thought of as obstacles that prosecutors must clear in order to win their side of the case. You might think of each of these burdens of proof as hurdles. Some burdens are easy to prove, and those hurdles are shorter and easier for a runner to jump over. And some burdens are harder to prove, and those hurdles are taller and harder for a runner to jump over.
An example of a very short hurdle is probable cause. This is a very low burden of proof. Probable cause means that there is a reasonable basis to believe that a crime may have been committed. Prosecutors only need probable cause to charge someone with a crime. The highest burden of proof in our legal system is called proof beyond reasonable doubt. A defendant in a criminal case is always presumed innocent until proven guilty. In order to prove someone guilty of a crime and get the conviction, the prosecutor must prove beyond a reasonable doubt that the defendant did the act.
If a single juror has a doubt that's based on their own reason and common sense, then the state has failed to prove their case beyond reasonable doubt, and the defendant is found not guilty.